In this lecture, we're going to talk about so-called aesthetic functionality, and it's a tricky topic for trademark law. What do we do when the product feature in question is not what we would call essential to the functioning of the article, or rather the danger to competition from protection comes from matters related to aesthetics, looks, style, that sort of thing. And the dividing line between the utilitarian and the aesthetic is a fluid one. I mean, courts have a clear preference for, what we would consider utilitarian arguments, but there are many situations where an aesthetic style claim could be styled as utilitarian. And, you'll see judges sometimes agreeing or understanding that form can be a form of function. There's litigation out there, Shire versus Bar Labs, in which a pill color is deemed to be functional because the use by generics makes dispensation of equivalence easier. It's easier for patients if they can expect that a certain kind of drug comes in a certain color and able to distinguish for those who have to take more than one kind of pill, if they are able to color code the pills based on what the pills are being taken for. And so there's this general tension when we think about so-called aesthetic functionality, because sometimes a feature does not make the device work, but it is still a part of the market appeal for reasons that have nothing to do with the reputation of the trademark holder. Nonetheless, courts are very fearful, I think wrongly, but who cares what I think, that if they go too far with admitting aesthetic arguments, functionality arguments that are not purely utilitarian, they're going to undermine the creation and protection of marks that are attractive. For example, in an opinion from the Seventh Circuit, Judge Easterbrook concedes that fashion is a form of function. However, he thinks that trademark law would be a cruel joke if somehow companies were discouraged from trying to find attractive trademarks. And so there's also an introdoctrinal tension here, and something we've talked about in previous lectures, about the kinds of marks we let in on the front end and the pressure that puts on the functionality doctrine. So the Trademark Manual of Examining Procedure has this excerpt that takes the view that many aesthetic functionality cases are actually about ornamental design, things that are decoration, things that aren't distinctive in the trademark sense in the first place. And that's all well and good, but what do you do if some fact finder or some gatekeeper has let some ornamental matter in? And then what do you do? And the Trademark Office recognizes that some features provide competitive advantages and should be open to copying. But then we get tricky questions when it comes down to actual cases. So for example, Valentine's Day, heart-shaped boxes. Are heart-shaped boxes protectable? Why or why not? So the restatement takes the view that it's the kind of thing that ought to be seen as functional, even though you don't need a heart shape to for the task of boxing chocolates. So on the restatement's view, a design is functional because of its aesthetic value only if it confers a significant benefit that cannot practically be duplicated by the use of alternative designs. So note that this view that when we're dealing with matter that is protectable for its aesthetic qualities, there should be a higher bar to making that kind of claim. The impact on the market of protection should be significant. And so in the restatement's comment, if having a heart-shaped box is an important factor in the appeal of the product to a significant number of consumers, then the shape is functional because there are no alternative designs capable of satisfying the aesthetic desires of these prospective purchasers. And that should echo what you see in the Qualitex standard, that a design is functional if protection would put competitors at a significant non-reputation related disadvantage. You can see echoes of these kinds of sentiments, although this is a case that comes before Qualitex, in Wallace Silversmiths versus Godinger Silver Art Company. There you have trade dress infringement alleged by a silverware designer when both the plaintiff and the defendant were marketing silverware in a sort of Baroque kind of style. And the silverware was certainly similar, and the court actually recognized that there was some evidence in the record of confusion among consumers and the prospect that the defendant's designs were in fact inspired by the plaintiffs. Nonetheless, these are functional. Why? Because it goes to the nature of the market. There is a market for Baroque style silverware. And so if you're going to have effective competition in that marketplace, people have to be able to use similar kinds of scrolls, flowers, that kind of thing. And there's something very problematic if the plaintiff were able to exclude competitors from using the elements necessary to compete. In many ways, it would be like claiming a generic term. And, the court still allows that, if we had identical designs, maybe we would have a different result. So the court doesn't quite want to bite the bullet and say, you can't get any protection for your trade dress. But the problem here is that what you're seeking is a protection over the whole style. So insofar as you may have a trademark, it's a thin one. And so note that we have this level of generality problem. Are we thinking about competition in, silverware generally, or are we thinking about competition in the Baroque style? If we reach the level of generality where the market definition is the Baroque style, it's so much easier for a court to find that the feature in question is functional. But again, the courts are very concerned about this idea that we don't want to discourage pleasing marks, and we already have a bar on ornamental features. And you see this kinds of tension and the court's reluctance to really bite the bullet and follow through on aesthetic functionality arguments in the case involving Louboutin shoes. And so Louboutins have these, striking red soles with a contrasting outsole, and Louboutin brings suit against the shoemaker that has a similar color of red on a monochromatic as opposed to a clashing shoe. And so there's suit brought, and the district court says, no. You are claiming protection over a functional feature. Indeed, in the record, there is evidence from the designer of the shoes that you had non-trademark reasons for choosing red for the outsoles. He stated that he chose the color to give his shoe styles energy, and because it is engaging. He also said that red is sexy and attracts men to the women who wear my shoes. And so those are non-reputation related reasons for choosing the color red. More than that, there's a potential monopoly problem. That if you award one participant in the designer shoe market a monopoly on the color red, that will impermissibly hinder competition among other participants. Because competitors in the fashion industry, my goodness, the fashion industry have reason to use similar color on their outsoles. And, maybe they want to reference other articles with similar colors, right? You want to mix and match your one's accessories and outfits. Maybe you want to have a monochromatic shoe. Maybe you want to have color coordination with other attire. In this respect, Louboutin's ownership claim to a red outsole would hinder competition, not only in high fashion shoes, but potentially in the markets for other women's wear articles as well. And the problem of functionality, or of trying to claim a particular color, are especially acute when we're talking about fashion.
In 2002, Oscar de la Renta did a collection of cerulean gowns, and then I think it was Yves Saint Laurent, wasn't it, who showed cerulean military jackets. I think we need a jacket here. And then cerulean quickly showed up in the collections of 8 different designers. And then it filtered down through the department stores and then trickled on down into some tragic casual corner where you no doubt fished it out of some clearance bin. However, that blue represents millions of dollars and countless jobs. And it's sort of comical how you think that you've made a choice that exempts you from the fashion industry when in fact you're wearing a sweater that was selected for you by the people in this room.
The market is always changing. What is in at one time may not be in another. And so if red were to be in, or the Louboutin shade of red were in at some time, then its mark would, in the words of the court, cast a red cloud over the whole industry, cramping what other designers could do while allowing Louboutin to paint with a full palette. And so, your mileage may vary. I find this argument completely persuasive. The Second Circuit on appeal did not. And the court, this is where you really see that reluctance to go too deeply into functionality arguments. And the court just says, look, Qualitex says you can have color marks, and what the district court does is effectively adopt a per se rule against them. And Qualitex says if you're going to do a functionality argument for color, it's got to be individualized, fact-based inquiry into the nature of the trademark, and cannot be read to sanction an industry-based per se rule. I think that's overreading what the district court does, but who cares? They're congressionally appointed, and I'm not. And they go on to say that a de facto per se bar is unnecessary. The functionality defense does not guarantee a competitor consider the greatest range for their creative outlet, but only the ability to fairly compete within a given market. And so interestingly, though, the court found other reasons for Louboutin to lose this case. They limit the scope of the mark, and they make the determination that the defendant wasn't engaging in what is a use of the mark for reasons that we'll talk about later in the course. This is a kind of a strained argument, but it does what the Second Circuit wanted to do: get rid of this case without expanding the functionality doctrine. And there's other intradoctrine channeling issues that can come into play in these cases. So consider, for example, Automotive Gold versus Volkswagen of America Incorporated. So there the defendant is selling auto accessories that bear the plaintiff's well-known marks. And so, you have a keychain that has a Volkswagen on it, or a license plate holder that has the trademark on it. And so why would anyone want to buy this kind of thing? The idea is that if you own a Volkswagen, you want to have auto accessories that match. And one of the ways you can match is by having something with a similar trademark. And the district court says, right, that makes sense. If you are selling the license plates or plate frames, keychains, that sort of thing, that's a functional use of the mark, and therefore there's no trademark infringement there. And the Ninth Circuit says, no. We are reversing all that. And here, too, I think we see an issue of intradoctrinal relationships within trademark law. And here, not so much about what's allowed in on the front end, but rather on the back end about what kinds of defendant uses of trademarks are permissible and what kinds of practices should be prohibited by trademark law. Specifically here, we have a situation where a defendant is selling something emblazoned with a mark without representing that it is in any way, that the trademark holder is in any way the source of the product. There's disclaimers and the like. And so the baseline argument is that someone is saying, I'd like a Volkswagen keychain. Sure, here you go. I'm not actually with VW. No problem. Here's the keychain. Independently of whether you take issue with the idea that the consumer is not confused, I think one of the things that's going on here is that the court is saying that even if the consumer is not confused, that is not a good thing. There's a strain of morality running through this opinion, and the court at one point says this is nothing more than the naked appropriation of the mark. So suggesting that there is something wrongful going on, and taking umbrage almost at the idea that the functionality doctrine could be used to justify so incorrect a practice. But it's debatable as to whether or not this is an acceptable practice or not from a moral perspective, and whether or not it's trademark's role to police morality. But that tone, that undercurrent, is running through this opinion. It's not so much an undercurrent as it becomes explicit at a point. In any case, so what are the potential trade-offs here, right? Is this the kind of market that should be under the control of Volkswagen and Audi and the like? In other words, do merchandising markets, which this essentially is, should they properly belong to the trademark holder? If it doesn't, does that affect their potential incentive to produce attractive marks? Or are Audi marks on the cars going to become less attractive because you can't get a merchandising right? And is there actual potential confusion here? So all these issues are raised by this case. Now, in the analysis, the court says, look, this is not a utilitarian mark. It's not the reason the product works. But again, what does it mean to work? To work, does it mean that it holds your keys on a keychain? Right, then of course not. Does to work means that it complements your choice in a car? Well, then maybe there is an argument that what you need to have is the actual trademark. And that also goes to the view of the court that this doesn't affect the cost or quality of the product. But then we get to the aesthetic functionality question. And here the court says, look, simply contributing to the appeal of a product is not functionality. That view itself, far from protecting competition, actually hurts competition. So again, we're dealing with the incentives of the trademark holders, and this is the thing that the court is afraid of undermining. And insofar as you want to claim an aesthetic feature of a mark, it's got to be limited to a feature that goes beyond the source identifying function. So if you want a VW as a complementary good, well, the VW is also the thing that performs the source identifying function on a car, and so that doesn't fly. You got to find a mark feature that isn't about the source identifying function. And to quibble with that, as you can clearly see, I'm quibbling with as much of this opinion as I can, that I'm not sure the source identification function is being performed here. Yes, you see that it's VW, VW, but that's not why you're buying it. And I would argue that it's unlikely that a consumer thinks that VW is actually behind the products in question. But that, again, is, I think, sort of the policy judgment that the court is making, that the consumer should not be able to buy this kind of thing from anyone other than the trademark holder. Okay, and so here again, we have this question about what the market is. Is it keychains? Is it complementary keychains? Is it Volkswagen keychains? And of course, at a high level of generality, if we're just dealing with keychains in general, then of course there's no competitive need for the marks specifically. If, of course, we're dealing with a market in complementary goods, we have this question about whether or not there actually are alternatives to the use of the marks. And so I would argue that the source identifying function is not actually being implicated and that there aren't necessarily core trademark purposes being served, but in any case, we have this interplay of doctrines. The court is kind of looking ahead to the merits and saying what is or is not acceptable behavior and using that to shape the scope of exclusionary doctrines like functionality. The court is also, I think, concerned that functionality in many cases is strong medicine, that to say that a mark is functional is to deny it protection, and that would be the death knell of trademark if functionality arguments were entertained here. But of course, there's no real reason why a mark can't be functional in one context while still retaining trademark significance in another. So even if VW couldn't be used to brand keychains when the VW was the actual product itself, that has nothing to do with the VW mark's ability to identify and distinguish a Volkswagen car. But again, the court is very nervous about that. And so we see the court's view of the liability issues shaping its approach to exclusionary doctrines and defensive doctrines like functionality. And of course, underlying all of this, as I said before, is the moral component that this is nothing more than the naked appropriation of the marks. So a couple of takeaways, summarizing ground that we've covered already. There's a lot of judicial discomfort with the aesthetic functionality doctrine. Many circuits refuse to even say that it is a thing that exists. Courts are much more likely to demand a showing of competitive need where aesthetics are concerned, and a need for the source identifying aspect of the mark is unlikely to cut it, right, as you see in a case like automotive gold, and the availability of alternatives is much more important to courts in aesthetic settings than in utilitarian settings, and therefore it's preferable if one can find some kind of utilitarian basis for arguing functionality, even if the feature in question is not intrinsically bound in the operation of the product. And here we see another example of policy overlaps within trademark law, that a refusal for ornamentation might prevent a lot of disputes about functionality down the line, but if something gets in at the level of trademark admissibility, the functionality issues become challenging at a later stage when we reach litigation. Thanks very much.